The skilled searcher, an IPR estoppel. The Federal Circuit has issued an opinion on the burden of proof for establishing estoppel in a case involving an inter partes review (IPR) petition. The case is Ironburg Inventions Limited versus Valve Corp. As the court noted, before closing arguments, the parties and the district court agreed that each juror should have the accused product in hand, and that device, a handheld controller for playing video games, was mailed to each juror. The jury returned a verdict of willful infringement and assessed damages of over $4 million. Valve had filed an IPR petition about 10 months after it was sued. Ironburg filed a motion to stop Valve from presenting certain patent invalidity theories at trial based on various grounds. The district court granted the motion, finding that Valve was stopped from asserting those grounds. The district court held that Valve had the burden of proof to show that it wouldn't reasonably have raised the disputed grounds in its IPR petition. The Federal Circuit found that because the non-instituted grounds were explicitly contained in the petition, and were thus raised during the IPR, Valve couldn't raise them again in district court. The court found that, because the district court improperly placed the burden of proof on Valve, to show that it could not, reasonably, have raised the non-petitioned grounds in its petition, when instead the burden of proof rests with Ironburg to prove that these were grounds. The court then agreed with the district court's reference to conclusions by other courts that an IPR petition reasonably could have raised any grounds that a skilled searcher conducting a diligent search reasonably could have been expected to discover. Thus, said the court, we hold that, provided the other conditions of the statute are satisfied, Section 315(e)(2) stops a petitioner as to invalidity grounds a skilled searcher conducting a diligent search reasonably could have been expected to discover, as these are grounds that the petitioner reasonably could have raised in its petition. The court concluded, the inquiry into what a skilled and diligent searcher would reasonably have discovered is ultimately concerned with what the searcher of ordinary skill would find through reasonable diligence and not what an actual researcher in fact did find through whatever level of diligence she exercised. Protect your patents. Visit us at www.eonlaw.com. Eon Law. Unleashing Genius.